What's the holdup? It's trespassing.
Pardon?
I don't understand what the holdup is. It's trespassing. I could technically leave and you guys could issue a warrant as long as I don't return. You can kiss my ass. This is
You know what? No. I'm gonna tell you what. You don't come in here. You don't.
Fuck you.
Okay, that's contempt. That's 93. Keep going.
Fuck you.
That's another
Fuck you
93.
again.
That's another 93.
Fucking game.
That's another 93. That's another 93. That's 6 93s consecutive.
This case erupts from the very first second, and trust me, you're about to witness one of the wildest emotional turnarounds ever seen in Judge Simpson's courtroom. Moments before this hearing, the defendant exploded in a tirade so intense that it racked up multiple contempt charges in seconds. 6 back-to-back 93-day counts delivered like rapid-fire penalties. That's not ordinary courtroom chaos. That's a meltdown with consequences measured in years, not days. In today's breakdown, we're diving into the psychology, the pressure, and the legal mechanics that turned a simple trespassing case into a near disaster. You'll see how frustration, homelessness, hunger, and hopelessness collided in one volatile moment. But you'll also see how accountability, humility, and timing can completely reshape a case that looked doomed. Judge Simpson enters this hearing already knowing the outburst was extreme, but he's also looking deeper. He knows something pushed this man past his breaking point, and today, both sides are trying to explain why. This intro sets the stakes: a defendant fighting personal demons, a judge balancing compassion with authority, and a courtroom waiting to see whether this apology will be enough to reduce 558 days of self-inflicted sentencing. Let's get into it.
Oh, there they are. I'm sorry. Court does call the cases of the people versus Daryl Jarrell.
So on behalf of Township.
Ron Brown appearing on behalf of Daryl Jarrell, Your Honor.
Good afternoon, Your Honor. Daryl Jarrell.
Defense counsel has filed an emergency motion to attempt to purge the contempt in this matter.
You have.
And I first give the floor to my client.
Pardon?
I'm giving my client the floor.
Your Honor, there's no excuse for what I done, man. I lost my composure and I directed my frustrations at you. I apologize for being disrespectful to you and your court and wasting time, the people. Hopefully you accept my apology and reconsideration of the time you've sentenced me to.
This is the moment the defendant begins damage control. After an explosive courtroom outburst, apologies matter, but only if they're credible. Notice how he acknowledges losing composure, admits misdirecting his frustration at the judge, and recognizes the wasted court resources. Legally, remorse weighs heavily in reconsideration hearings. Judges don't expect perfection from defendants, but they expect accountability. His attorney smartly reinforces this by emphasizing the emotional and personal turmoil behind the meltdown, linking the outburst to untreated struggles, employment challenges, personal instability, mental stress, creates context without excusing behavior. This is strategic. Courts are often more lenient when defendants show insight into their mistakes and a plan for improvement. But here's the tension. Even with remorse, he's trying to undo 558 days worth of contempt sentencing. Apologies help, but they don't erase the severity of what happened. Would you, as the judge, give him another shot after this apology?
Thank you.
Your Honor, we have referred him to our aimed social work division to help him work through in some of the personal issues that he's going through that culminated in his outburst in court. You've been a judge for a very long time, set a very high bar for people as they appear before you. I think we communicate differently. Some people, even though it's socially inappropriate, use profanity, and profanity can be used as an attention getter. And I think it got the court's attention, but he's in need of service.
Oh, he did.
He's in need of services, Your Honor. He's in need of services, and we're trying to sort through a plan to present to the court, if you would accept his humble apology to help him move the cases forward.
Anything from the people?
Well, Your Honor, we were all present for it. I had a chance to review the video. It's actually worse than what the court noted. Right? I'm sure the court's has seen the video, but it was worse than what the court noted. I will leave it to the discretion of the court, but if there's going to be a modification or change of the sentence imposed by the court, I would certainly like there to be a plan in place for Mr. Durrell. Seems that would be the minimum or would be to alter or change its sentence.
Mr. Durrell, what was going on with you?
Now we see the human side, both from the defendant and from Judge Simpson. Simpson's question isn't accusatory, it's investigative. He wants to understand the root of the emotional eruption. When the defendant explains unemployment, homelessness, and frustration with charges he feels are unjust, this paints a fuller picture. This is crucial. Personal instability often fuels courtroom outbursts. Hunger, exhaustion, and housing insecurity intensify stress to the breaking point. Judges see this every day, but few defendants articulate it honestly. His admission that it falls on me is also a turning point. He's not blaming the system, he's acknowledging his role. The defense attorney then warns of a dangerous precedent. If this behavior is not addressed thoughtfully, others might see it as permission to act out. Courts must balance compassion with deterrence. This section shows the delicate dance. The system tries to rehabilitate without encouraging chaos.
Well, there's a lot of issues that I'm under currently. One, I'm unemployed. I can't obtain a driver's license. Without those, it's hard to provide for yourself. The charges, once we get into it, you'll see that they're frivolous charges. They should have never been brought to the court's attention. They're minute trespassings that aren't even trespassing. I used an easement for one, and the other one should have been dismissed. Just frustrations, man. There's no excuse for what I've done. You wanted an in-depth look. I shared some things. I mean, it falls on me, man.
No, it does.
And he realizes that this case, many other people are watching, and how the court handles it. We're hopeful that others won't use this as an example to act out as well.
Well, but from the very beginning, the one thing that, as Mr. Brown correctly points out, I've been doing this a minute. And, you know, Mr. Durrell, you were in my court, and I watched you because you were sitting in the back. And you were sort of a dichotomy of things for me. Because as you sat back in the back of the courtroom, you sat there very respectful. You had your ball cap on. When you came through, you took your ball cap off. You did everything. You sat in that back row, just patient as all could be. When you came up, you again, initially it was fine. You were maybe upset by the charges, but a lot of people were like that.
Right.
And it was going fine, and I could overhear, just so that you understand what I was trying to do, I overheard, as you were talking to your attorney, that you didn't have a phone.
Right.
You didn't have email.
Judge Simpson is essentially revealing his mindset before the explosion occurred. He had noticed the defendant sitting quietly, respectfully, even removing his hat. In the judge's eyes, this man didn't walk in as a problem. This reinforces a major point. Judges often make decisions based on courtroom behavior long before the defendant reaches the podium. Simpson was attempting to help him by giving extra time to coordinate with his attorney via mail, because the defendant had no phone or email. That's a huge detail. The judge was trying to accommodate his lack of resources, but the defendant interpreted it as the system dragging its feet. This miscommunication snowballed into frustration, then anger, then contempt. It's a powerful reminder that perception drives reaction. The judge intended mercy. The defendant felt pressure. And in that gap, everything collapsed. Question for the audience. Do you think the judge should have explained his reasons sooner to avoid misinterpretation? Or was the defendant responsible for keeping his temper in check?
More than anything in the world, I was worried that you weren't going to be able to have adequate time. I would have just normally set it 2 weeks out, done whatever. And I was trying to give more time, not to delay it,
Yeah,
but to try to make sure that if you had to get in touch with Miss Perry by letter, you guys had to do that or do whatever,
yeah. See, I was thinking
that
about the other.
there be time for that to happen. And that seemed to aggravate you, but I think, when I look at it, you were aggravated because you thought the system was kind of dragging out.
Good.
But I was doing that for your benefit.
My apologies. I'm again misunderstood.
And so then when you wanted me to, then you wanted it done sooner. So then I said, okay, I just said, well, move up to date. I didn't know it wasn't going to be helpful for you, but what the heck? And then that's when you went off.
I did.
And I've had people go off in front of me before. Doesn't bother me. It's gonna happen, I guess. But you just got yourself worked up to the point that as you were headed down and out, I'm just thinking, I don't know why you want to battle. It's a battle you can't win.
Right.
This is some of the most honest judicial commentary you will ever hear. Judge Simpson walks the defendant through the psychological unraveling, agitation, buildup, explosion, regret. Many defendants only realize the gravity of their actions when the jail door slams behind them. That sound has a way of cutting through anger like nothing else. Simpson isn't berating him, he's educating him. Contempt isn't symbolic, it changes the trajectory of your life. A 30-day trespassing case ballooned into 558 days because emotions overpowered logic. But the judge also acknowledges something important. Regret sets in quickly. And for this defendant, it hit the moment he was taken back and sat alone. Vulnerability surfaces, and anger fades into fear, confusion, and sorrow. The judge is trying to prevent this man from repeating the pattern. This section shows how easily a minor case can derail someone's life when emotional control breaks down.
Silly me.
Yeah, silly, stupid. There's a lot of words. Maybe start with that because it didn't make any sense,
No, not at all. You're right, man.
right? And I'm going to tell you something. And I'm not saying this to embarrass you because you're in good hands with the folks at the public defender's office. You need a break, right?
Yes, sir.
You need something to go in your direction.
Yes.
Yeah. And it seems everything, you can correct me if I'm wrong, everything you had been doing, none of it was quite working out.
Nothing.
Trying to get rid of stuff. This is one of the things you wanted it done and gotten rid of so you could try to move on to that next thing.
Absolutely.
And I'm not saying this again, I'm not saying this to embarrass you, but sometimes things get tough. You get yourself wound up. You get to a point, and then for a brief moment you regret it. You're not sure where to head. Am I right?
Yeah, sometimes.
And I think even that day, for a brief moment, you regretted what had happened.
Absolutely. As soon as I said it, but I was fueled.
And it's because when you got back there, and all of a sudden that door shut behind you and locked up, you realized something.
Oh, man.
Yeah. And as it was described to me, right or wrong, you were sort of laying there on the floor crying.
Wrong. I was sorrowful.
Look.
I may or may not have.
No,
I don't
listen,
recall.
just listen. There's no embarrassment there. There's not.
The defendant tries to correct the narrative, saying he wasn't crying, he was sorrowful. But honestly, that distinction doesn't matter legally. What matters is that the judge is acknowledging his emotional collapse without shaming him. This is a key moment of judicial professionalism. Simpson emphasizes that nobody was mocking him. The staff reported his state because they were concerned. Courts have a duty of care once someone is in custody. When a defendant goes from furious to emotionally undone, that signals deeper issues that require attention, not punishment alone. The judge is effectively saying, your emotions don't embarrass me, they concern me. That's huge. Many defendants expect hostility from judges. Instead, Simpson shows compassion while still maintaining authority. This also builds the foundation for future leniency. A judge who sees genuine remorse and emotional vulnerability is more likely to reconsider harsh sentencing.
I got it reported to me
Right.
because I was worried about you. I
Right.
didn't, nobody was trying to say to embarrass you or do anything. You had gotten yourself to a certain point. Something got out of control. And now you had to figure, you took a circumstance that was kind of bad, made it even worse. Now you have to figure out how to get out of that.
Right. Absolutely. Yeah, for sure.
Okay. You had left here that day. You don't have a place to stay, do you?
No, I'm currently homeless.
Yeah.
The Delana Center.
Pardon?
The Delana Center.
But are you there most of the time?
They have a waiting list period.
Yeah.
So as long as you continue to check in, I think they do a triage. Just to know that you're interested in a room there. They'll continue to screen you, and when one comes available, they'll offer it for housing. Until then, you sleep wherever you can, you know, couches, wherever, tents, bridges, parks. As long as the cops don't push you along, you know.
So the reality is you didn't have a place to go, right?
Oh no, I don't have a place to go. No.
All right.
Judge, he's even sleeping.
Pardon?
He was sleep deprived. He's sleeping. He's
Yeah,
got a roof
I
over his
probably
head.
was sleep deprived a little bit too. Man, I couldn't stop falling asleep. Did you notice that? Couldn't, man.
I just thought it was my relaxing voice and personality. Mr. Allen, actually today, you look a whole lot better than you did that day.
Thank you. I feel better too.
Before you came in, when was the last time you ate?
I ate probably the day before.
So you hadn't eaten that whole day.
No. I actually went to eat, but I didn't have enough time to jump on the bus and come back, so I skipped it. Yeah. I think
What
I
do
may have
you-
had some donuts for breakfast, though.
Okay.
I think I may have.
What do you think I would do with you after what you did?
And you can do anything you want with me, Your Honor.
This line reveals total surrender. The defendant has moved from defiance to desperation. He's no longer trying to argue law. He's pleading for mercy and asking to be released until the September 4th hearing. But then he makes a critical mistake. He starts predicting the legal outcome, claiming the charges will probably get thrown out. Judges hate this. It's seen as overstepping, and Simpson calls it out immediately. You cannot practice law without a degree, even in your own case. His attorney gently reframes the request, suspend the contempt sentence, hang it over his head, let him prove he can behave. This is smart advocacy. The judge's next statements hint at fairness. He won't let disrespect slide, but he acknowledges the man's hardships. We feel the balance shift here. Simpson is preparing to reduce the 558-day avalanche into something manageable, but he won't erase it entirely. Would you trust the defendant with another chance at this stage?
Oh, I know I can.
What I would like you to do for me is to let me go, and we'll have continued scheduling of the September 4th date. And you'll see that I've told you the truth about the charges that are pending. They'll probably even get thrown out by then.
Pardon?
Once the prosecutor reviews them, they should probably get thrown out.
Well, probably you're about to try to make another mistake. And that is you're trying to practice law, even though it's about your case and you don't have a law degree. Why don't you leave it to the experts that are around you?
And
Yeah.
Sounds good.
I think he's suggesting that you suspend or hang it over his head. Contempt,
What
if
day
not
was that we sent him in?
purge, Your Honor.
I got it here in here. It was the 7th. Today's the
No. Set it for September.
No, I know I set him for September, but I said sentenced him. Yeah. I can't just let you walk away from it. What you did is, so that you understand, this really isn't about you or me. It's about you,
Yeah.
but it isn't about me. You can say all those things you want, but the one thing in the past 25 years, I will tell you, I do not let people just disrespect this institution and walk away.
Right.
All right. It just won't happen with me, and I'm sure Mr. Brown has told you that. I just don't.
Okay.
I understand, however, and balance that against sort of where you are and what you're trying to do. So we're currently set for September 4th at 9 a.m. What I'm going to do regarding the contempt, I'm going to work it this way. I will grant to a certain extent the motion, and I'm going to reformulate the 558 days that you talked yourself into. And when you're back there thinking, think about this, how you took a case with a maximum 30-day sentence and parlayed that to 558 days.
Right. Okay.
So what I'm going to do is take the 558 days. I will indicate defendant is to serve 93. I will give him credit for the 6 that he's been in and suspend at this time the balance.
Thank you.
When we come back, so it's down to 93 now. When we come back on the 4th, I'll consider whatever else I might do regarding that sentence.
Thank you, Your Honor.
Whether or not you serve the rest of it is going to be dependent upon your behavior, how you come into court. I don't ask anybody to, talk up to me. They don't have to like me. That's not my job. I'll tell you what, I like this Jarrell better than that other one I saw.
Right.
So let's just keep that up. You'll at least, and I don't like doing it this way, and I don't like saying it, you'll have a place, right? You're going to be eating regularly, and you're going to be looking a whole lot better, I think. I don't like doing it this way, but
Right.
maybe some benefit can come out of it, and you'll be able to get with their aim division and see if we can just get certain things in place for you.
Right on.
All right, fair enough?
Yeah. Yeah. That's all I can ask for. Thank you.
Well, I'll tell you what, don't thank me. That man standing beside you, that's who you need to thank, because he was on me, and he was trying to explain and trying to make sure he didn't want to say anything off the record without Mr. Siller there, but he was in your corner batting for you. And so you ought to be thankful for that. Because quite frankly, whether you sat there 558 days or not, I was going home for dinner. So wouldn't have mattered to me.
All right.
Okay.
Yes, sir.
Thank you.
Take care. Thank you. Somebody write what I wrote in one file and the other one. Thank you.
This final ruling is a masterclass in judicial restraint and proportionality. Judge Simpson reduces the defendant's self-inflicted 558-day contempt sentence down to 93 days, with credit for time served and the remainder suspended. In other words, the defendant now holds the keys to his own future. If he returns to court respectful, stable, and sober-minded, he may never serve the rest of that sentence. If he slips even once, the remainder can be reinstated instantly. Simpson also acknowledges the defendant's struggles, homelessness, hunger, instability, and expresses hope that structured support services will help stabilize his life. But he reinforces a non-negotiable truth. In his courtroom, disrespect has consequences. The takeaway is powerful. Emotional regulation can save you months or years in front of a judge. And even when a defendant spirals, humility and honesty can still shift the outcome dramatically. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.